A police car pulls up to your house and they handcuff you and arrest you. And in that moment, only one thing crosses your mind. What now? But the question you should actually be asking is this. After you're arrested, should you stay silent during those first few hours or should you talk? The wrong answer can change the course of your life forever. Imagine two police officers ringing your doorbell at 3 in the morning. A few minutes later, those handcuffs are on your wrists, something you've never experienced before. Most people think in that moment, I'm innocent. If I talk, everything will be fine. But sometimes that's exactly why thousands of innocent people end up in court. Haven't you heard stories of people sitting in prison for decades for something they didn't do? You could be in their shoes. And by the way, even if you are guilty, the first statement you give can change the severity of the punishment you receive. First, know this. Police do not necessarily need a court order to arrest you. If there is sufficient suspicion, called probable cause in law, they have the right to arrest you on the street, in a vehicle, in a park, or in front of your home. But here is where something most people don't know begins. From the moment of arrest, you have certain rights. These are not rights written on paper just for show. They are written in the Constitution. They have been confirmed repeatedly by court decisions. The problem is, nobody is shouting these rights at you in that moment. And many people make critical mistakes after being arrested simply because they don't know what they should do. The police car moves and approaches the station. An officer looks at you and asks, "So tell me, what happened?" You need to know in advance what happens when you answer and what happens when you choose to stay silent. And most importantly, do both lead to the same outcome? No, and that difference can change everything. Most people assume, if police ask me questions without reading me my Miranda rights, what I say cannot be used in court. The reality is more complicated. Miranda rights, that is, your right to silence and your right to an attorney, only apply at a specific moment, not for every interrogation. And if you miss that moment, things change. But how? We're explaining that right now. In 1966, a case in America changed the course of everything. A man named Ernesto Miranda was arrested after being questioned. He confessed. He was convicted. Then an attorney noticed something. No one had fully informed him of his rights. The case was taken to the Supreme Court, and the court said, from this point forward, before a person is taken into custody and questioned, officers are required to inform them of the following. You have the right to remain silent. Anything you say can be used against you as evidence in court. You have the right to an attorney. You can request the assistance of an attorney to protect your rights. We call these Miranda rights today, and these rights apply in every state in America. But here is the critical point that most people don't know. Miranda rights do not have to be read at the moment of arrest. They must be read before questioning begins. Police can arrest you, take you to the station, and even complete booking and procedural paperwork. During this entire process, they are not required to read you anything. They are only required to inform you of your rights before they begin asking questions. And the most important thing to understand right now is this. Simply staying quiet is not enough to exercise your right to silence. In 2010, the Supreme Court stated clearly, simply remaining silent does not mean you have invoked your right to silence. So even if you don't say a single word for 3 hours, if you eventually answer one question, that answer can be used in court. You need to know how to properly exercise your right to silence. You will say it clearly and out loud. I am invoking my right to remain silent. I will not say anything without speaking to my attorney first. That is one sentence, and that sentence can change everything. But what if you can't afford an attorney? The Gideon versus Wainwright case from 1963 resolved that too. If you cannot afford to hire an attorney, the state is required to appoint one for you. This is not a favor. This is a right. Within 48 hours of being arrested, you must be brought before a judge, and the case must be heard. The judge looks at whether the arrest was justified. Exceeding this time limit is considered a constitutional violation. Bail amounts can also vary from state to state. Some states have restricted the cash bail system. Others continue to use the old system.
Now let's look at real life. When thousands of cases are examined, the biggest mistake that emerges is this. People think that talking will help because they are innocent. I'm innocent, I have nothing to hide. This feeling is understandable, but law doesn't work that way. And sometimes the cost of simply being in the wrong place at the wrong time can be enormous. If witness testimony points to a single person, you could find yourself facing a legal machine determined to pin everything on you. First of all, know that a police interrogation is not a casual conversation with a friend. It is a serious and formal exchange. Don't forget this word. That conversation you are having is entirely official and on the record. Every word you say there is being recorded. It can be misunderstood. It can be taken out of context and lead you somewhere completely different. It can appear contradictory. Innocent people have put themselves in very difficult positions by saying one sentence the wrong way, suddenly appearing suspicious. This is not a movie scene. This has happened in real life many times. The biggest myth circulating on the internet is this: if police didn't read you your Miranda rights, you'll be released. Wrong. If Miranda rights were not read, it only means that what you said during that specific interrogation may not be usable as evidence in court, but that does not mean you will be released. The case continues. Other evidence is used. Another myth: if you ask for a lawyer, you look guilty. Erase that thought from your mind completely. Asking for an attorney is not a confession of guilt. It is a constitutional right. Guilty or innocent, this right belongs to everyone. And know this too: a DNA sample can be taken during arrest. Fingerprints are taken. Your photograph is taken. The Supreme Court found all of these to be legal. You cannot refuse requests like a DNA sample or fingerprints. But when they start asking you questions, that choice is yours. Knowing your rights does not make you innocent, but not knowing them leaves you defenseless. You want to know these rules before the handcuffs go on, because when that moment comes, there is no time to think. There is one sentence, simple, clear, and it can save your life. I am invoking my right to remain silent. I will not speak without talking to my attorney first. Memorize this, know this, because you don't need to be right to say this sentence. You just need to know it. Your rights only work when you know them. Subscribe to Rights Illustrated. See you in the next video.